You declined to prosecute a 61-year-old man who was putting his hands on himself on a park bench in front of children. Your office dismissed a case against a man who possessed and shared dozens of videos showing the R word and essayed of infants and toddlers. These dismissals lacked sufficient legal justification, exhibit gross abuses of discretion, pose serious threats to public safety, and undermine the public's confidence in the administration of justice. I write to address both cases. What's up, everybody? I'm Quisha King Benton. Welcome to the Quisha King Show. So I saw this on Twitter and I was just utterly disgusted. I got nauseous when I read what is happening here in Florida. Okay. A state attorney of the Ninth Judicial Circuit. I want to tell you about this first, and then I want to show you who it is. Okay. So it says, as you are aware, on August 16, 2025, a father and his two-year-old son, that's important, were at Kitland Nelson Park, a location that features a splash pad where children play. There were multiple families with children playing in the splash pad. At least one father noticed, and pictures and videos show a man sitting on a nearby park bench. I'm gonna give you fill in the details, but I need you to hear this first before you see, because we're too in our flesh and carnal minds. You know, when we see things, we're not in the spirit a lot of times. So I want to tell you this, and then I want to show you, so get your spirit right. At least one father noticed, and pictures and videos show a man sitting on a nearby park bench with his right hand in his pants, looking in the direction of the children. The father stated that his 2-year-old son saw the man on the park bench who was touching himself for approximately 5 minutes. Once the man finished, he removed his right hand from his pants and stood up. The park manager stated that when the man stood up, his shorts dropped, exposing himself. The man was arrested and identified as Kevin Chapman. Not only did your office fail to pursue pretrial detention, but it declined to charge him, claiming that the case was not suitable for prosecution. The purpose of bail determination, in part, is to, quote, protect the community against unreasonable danger from the criminal defendant, end quote. And they cite the statute. Upon motion by the state attorney, may order pretrial detention when the defendant poses the threat of harm to the community, end quote. Your office elected not to pursue pretrial detention and instead allowed a man back on the street who played with himself in front of small children at a children's park. Here's the other important part. Section 800 of this statute provides that a person who intentionally is touching themselves, exposes the genitals in lewd or lascivious manner, or, quote, commits any other sexual act that does not involve actual physical or sexual contact with the victim while in the presence of the victim who is less than 16 years of age, commits lewd or lascivious exhibition. The Supreme Court has held, quote, while the child need not be able to articulate or even comprehend what the officer is doing, the child must see or sense that a lewd or lascivious act is taking place for a violation to occur. The fathers, and they cite the case law. The father stated that his 2-year-old son was less than 50 feet from Chapman during the incident. Okay, first of all, he's 2. So it's not going to be a lot of comprehension and understanding. But the fact that the man is there in front of children, yeah, the child is not going to be able to understand, but that's where the adults are supposed to come in. According to the father, his child saw Chapman as Chapman was touching himself on the park bench. What's more, video and photographic evidence taken by the father shows Chapman with his hand down his pant on the bench in front of several other children who are clearly under 16 years of age. And according to the arresting officer, the park manager confirmed these facts. He witnessed Chapman on the park bench facing the splash pad and then observed Chapman stand up, lose his shorts, and expose himself. There is no doubt that Chapman's actions were disgusting and criminal. It is your duty to prosecute him. Yet your office never even talked to the father except to let him know that you weren't pursuing charges. He represents an obvious danger to children, families, and all decent citizens in your circuit. I strongly encourage you to reconsider dismissing the charge against Chapman. Now, what kind of person? This is the circuit, okay? They have attorneys under them, right? Like DAs. Now we understand that this attorney does not put their hands on every single case that their attorneys that are under them that they prosecute. That's reasonable. But something like this, I am sure, like this is something that would rise to your attention. You should prosecute this person. And when this attorney who is accused allegedly of letting these things go, their explanation is pitiful. But let me show you. This might tell you why people are really not pushing back on this. Monique Worrell. You might remember her name if you live in Florida, because this is the same state attorney that DeSantis actually removed from office because she was letting criminals out of jail. But the public re-elected her again. Now, I'm not trying to deal with Monique on her behaviors because I don't know if she is a believer or not, but I guarantee you there are people that voted for this woman who are believers, and that's who I want to talk to. The only reason that this woman can get away with stuff like this, with letting criminals off, criminals who would violate children in such a disgusting way, planting these seeds, getting his rocks off in front of little kids, imagining things with these little kids. The only reason she's able to get away with it is because she is Black. That's why. That's disgusting. Is your Blackness so important that you would not say something about somebody like this in your community who would allow, you won't even try to prosecute? Oh, well, I'm going to show you her pitiful remarks.
All things that are wrong are not illegal. And I'm not standing before you today telling you that what happened in that park was wrong. But I am standing before you today telling you that I trust the word of the attorney who was assigned to this case when he said, although those actions were wrong, he could not prove beyond a reasonable doubt that they were illegal.
When is the Blackness not going to be enough? When is it? Because she all the way down with all the abortion you can handle. She all the way down with all the LGBTQ. She's all the way cool with everything your Bible says don't be a part of. And you're supporting this person. You keep putting her in office. Have you lost your mind? And then you want to turn around, all you Christians, you want to turn around and talk about, well, what? Look at the country. Oh, things are just getting so bad. Oh, really? Perhaps it's because you carrying the light, You're not doing nothing with your light. You're not making sure that darkness doesn't come and sit over your city. You're not making sure that people like Monique don't get into office where they can allow more darkness into your land, into your region. You as a Christian are supposed to be taking that territory. You're not supposed to be just letting the enemy have its way. Are you crazy? You're going to let a man sit in a park, a splash park. Therefore, kids are probably in their little bathing suits and stuff. You're going to let him sit there and do this in your city? You ought to be ashamed of yourself. Y'all voted her in there. Y'all have to get her out. Enough of this foolishness. That ain't even it. Let me finish telling you what else Monique has been up to. This is another case. State of Florida v. Thomas L. Dogos. Following an undercover operation to identify individuals sharing child corn in Central Florida, law enforcement obtained a search warrant for the residence and all devices belonging to defendant Thomas Dogos. On June 4, 2025, officers executed the warrant, arrested Dogos, and seized his devices and computers. During the execution of the warrant, Dogos, post Miranda, admitted to possession content depicting naked children, images of minors. Yes. During an on-site forensic analysis of Dogos' laptop, investigators located at least 12 videos showing children as young as 2 years old being R-worded and battered. Dogos' search history showed the use of terms like, it's like baby, I don't know, and some other terms. Oh my God, I don't even want to read this. I can't even. It is just disgusting. I'm not even going to say it. Based on a preliminary view of Dogos' devices, it appeared he possessed thousands of images of child porn. His devices were taken by law enforcement for additional forensic analysis. This is making me sad, sick. I cannot. But we have to talk about this because these people cannot continue. This is insane. The Office of Statewide Prosecution on June 10 filed a notice of prosecuting authority, assuming prosecutorial authority over the case. On July 8th, OSP filed a 12-count information charging Dogos with enhanced possession of child porn under section blah, blah, blah. Okay. Given a secondary felony, given the volume and horrific nature of the content. On July 10th, after OSP took control of the prosecution, an attorney from your office, this is the letter that the state attorney, James Uthmeyer, wrote to Monique Worrell's office. Let's see. On July 10th, after OSP took control of the prosecution, an attorney from your office inexplicably dismissed all charges against Dogos. According to the docket, Dogos' bond was then discharged. In the interim, OSP received results from the forensic analysis. Based on the results, on August 28th, OSP obtained an arrest warrant for 48 additional counts of enhanced possession of child. And the recovered content featured infants and toddlers being R-worded. Fortunately, Dogos was apprehended days later at the Canada border and swiftly extradited back to Florida. And OSP intends to pursue the original 12 counts that were inexplicably dismissed by your office, as well as the additional 48 counts that were part of the August 28th arrest warrant. The depravity of the videos Dogos possess is impossible to overstate. OSP will ensure justice is done. He faces the possibility of 900 years in prison. Your office's dismissal of Dogos's charges was an unacceptable mistake. In this instance, we're lucky that the rapid diligence of OSP and law enforcement located him and got him back to Florida, but these errors cannot happen in the future. Your office should never dismiss a case OSP is managing, especially a case like this involving an individual who possessed and shared dozens of videos featuring the R word and SA of infants and toddlers. At best, it suggests a lack of adequate training in your office. Please address this deficiency and ensure that it doesn't happen again. Public safety depends on the faithful execution of your duties. You have the duty to prosecute criminal cases on behalf of the people. You neglect that duty when you knowingly permit criminal conduct and prefer no charges, therefore. It is also incompetent to exhibit gross ignorance of official duties or gross carelessness in the discharge of them, or from lack of judgment and discretion. And these are sightings. This is part of their job because they have notations by these remarks. A man who touched himself on a park bench in front of and perhaps two small innocent children should be detained and criminally prosecuted. Likewise, a man who possessed and shared dozens of videos featuring the R word and SA of infants and toddlers should be prosecuted. Your failure to do so in these cases breaches your duties as a prosecutor. In addition to neglect of duty and incompetence, it may further amount to misfeasance and malfeasance. So this is like, get your act together. Here is some stuff that you've missed, okay? This is your job. This is a big deal because we've had problems with you before, ma'am, okay? And for her to turn around and act like, they're just after me because I'm Black. You low down, dirty somebody, girl. Yeah, that's a really good question. How could you be doing those types of things in front of children and it not be a crime? Everything in us tells us that this is a crime, and Monique knows that it's a crime. The only reason that people don't want to make this a big deal is because she's Black. So let me ask you, if it was a white man who didn't prosecute another white man, would you be fine with that? Or the office didn't protect the citizens? When are Christians going to protect when are we going to protect society? Because we're depending on secular people. Because if this woman is supposed to represent what we believe should be upheld in society, she's not doing a good job. So Christians are supposed to, we're supposed to be the light in darkness. This is clearly darkness. So I'm just wondering, where are the believers? Or are you one of the ones that's just sitting back and letting this ride and you want to point fingers at James or the DeSantis office because they the wrong color? So forget the kids, forget their endangerment, forget all that. This is about racism. This woman literally said that it is not illegal for a man to masturbate in front of children. Even if it's on camera, even if it's on tape. This is what she's asking you to believe.
General in his letter would lead you to believe that of the thousands of cases that come into this office on a daily basis, that I personally review each and every single one of them and make a charging decision as to the case. And that is, again, factually inaccurate. And he either doesn't know or doesn't understand the process of how a state attorney's office works, or again, he just has a reckless disregard for the truth. I will leave it to the public.
No, there are other options. How about he's telling you, okay, let's say you just missed it, Monique. You missed it because other attorneys you don't have your hands on every case. That's reasonable. But he's alerting you to this and saying this should be prosecuted. And you are still saying, nope, I'm not going to do that. I don't have anything to do with it. That's the problem. Since you don't understand. He's asking you to take responsibility. Maybe you did miss it, but here you go.
Public to decide which one it is. However, in that case, there weren't any charges brought, and I'm going to show you the case notes from the attorney who handled that case, who happens to be here with me today. And I want to be very clear. I did not have any personal knowledge about this case, but it took me 5 minutes to read the case notes that were well written by the attorney who was assigned to the case, to understand what had actually happened in this case. So I'm going to share those notes with you today. It's important because I have asked my attorneys to be very, very specific in their case notes.
This says, spoke to victim's father about what happened and facts of the case. This is on September 17th, 2025. And facts about the case. He confirmed that the child did not see anything and wasn't aware of what was happening. Explained that, so I'm guessing the attorney explained, this is a note, so it's not like full on sentences. Explained that based on the language of statute, I cannot charge the exhibition, it's blurry, I can't really see. Also explained that because no adult saw the defendant genitals, that I cannot charge any misdemeanor crimes. Victim's father was upset, but understood the reason for being able to file, for not being able to file. If it's a victim, how is the child a victim? Nothing can be filed. This is crazy to me. This attorney is saying that because no adult saw the defendant's penis, I cannot charge any misdemeanor crimes. And then he also says that was a note on September 17th, but August 18th, 2025, it says need to review videos once received and need to speak with the victim's family. Case law seems to suggest that we must prove that the child was aware of what was happening in order to prove the F2 BARD, whatever that is. Florida courts have consistently held that the phrase in the presence of requires that the child either sees or senses the lewd act. The child was 2, and there's videos of this man doing this in front of other kids. This is crazy to me. So if a young child can't articulate that they saw somebody doing something like this, and how is it that no adult, it was on tape, no adult saw the defendants? This does not, so they're trying to say you have to see what is a lewd or lascivious act then? I mean, what about public indecency? I cannot believe this woman is trying to defend this.
So in these notes, you'll find that first, going back to August the 18th, the attorney did extensive research on what he needed in order to prove this case successfully beyond a reasonable doubt. So that was back in August. And you'll see there that he cites cases, the cases that he researched that would show him exactly what he needed in order to prove this case beyond a reasonable doubt. Now, I didn't make up those cases. Those cases were there. If you look at the citations on them, they're 1991 and 1992 cases. So this is before I was ever state attorney, before the attorney general was ever appointed to be attorney general. This is case law, which we as attorneys, practicing lawyers, use as a guidepost on how we go forward on cases. So after my attorney did his job and did the research on what he needed to prove the case, on September the 17th, he said he spoke to the victim's father about what happened and the facts of the case. Because as I told you, facts matter. He confirmed that the child did not see anything and wasn't aware of what was happening. He explained that based on the language of the statute, he could not charge the charge of exhibition, which would have been the felony in the case. And he also explained that because no other adult saw the defendant's penis, that he could not charge any of the misdemeanor crimes of exposure. He explained that the victim's father was upset, but he left the 45-minute conversation feeling that the victim's father understood why he could not go further. Now listen, we can't uphold the law and not uphold.
That is absurd to me. So she's saying that unless a child, no matter how young the child is, the person can act, that the child can say, yes, I saw it, or I mean, since that is so vague and other people are seeing it, it's on tape.
We can't go forward on charges that the law prohibits us from pursuing. And I would submit to you this morning that although they did a great...
But law is interpreted. That's why in his thing, it said, that's why they use case law to see, because James Uthmeyer, attorney general, he cites the same case. The child must see or sense that a lewd or lascivious act is taking place for a violation to occur. State v. Warner 609. Same one he has in there. According to the father, his child saw Chapman as Chapman was. But see, so James is saying that the father did say the child, and now this attorney is saying that the father didn't say he did. But it says, what's more, video and photographic evidence taken by the father shows Chapman with his hand in front of several other children who are clearly under 16 years of age. And according to the arresting officer, the park manager confirmed these facts. He witnessed Chapman on the park bench facing the splash pad and then observed Chapman standing up, losing his shorts and exposing himself. So she is not making a good case for herself. This doesn't make any sense.
So what you're going to see here is a notice of prosecuting authority. And this notice of prosecuting authority was filed, you'll see the date up there, on June 10th of 2025. That is the date that it was entered into the system. And this notice of prosecuting authority was filed by the Office of Statewide Prosecution. Now, this is a notice that happens within the normal course of business, so this isn't anything that's out of the norm. And the reason that the Office of Statewide Prosecution would file this is to let us know that the offenses are multi-jurisdictional, meaning that these things happened in places other than the Ninth Judicial Circuit. And when cases happen in multiple jurisdictions, the Office of the Statewide Prosecutor has jurisdiction to prosecute those cases. Guys, listen, it's intricate for those who don't operate in the system. It is. But
lies. I just did a quick Google search. It's shameful. It's so shameful. With just a quick Google search of when the Florida Office of a Statewide Prosecutor takes over a case, does the circuit judges and prosecutors, must they drop their cases? They said, no, you don't have to drop the case. They say they may drop it if there's like a tactical reason or whatever. But it's, to me, when I first heard this, it's like when somebody has federal charges and state charges. The state doesn't drop their case just because somebody has federal charges unless there's some strategic thing that they're trying to do. So she's trying to make it sound like, oh, we had to drop the cases. We had to drop the case. James Udmar, he should know better than this. He doesn't know what he's talking about. We had to drop the case because it included other counties. So this process happens or when there's multiple county, 2 or more counties that have a case. So you mean to tell, so what she wants you to believe is that when a case it spans over 2 or more counties, the original filer has to drop the charges. Do you know how stupid, do you know how many criminals we will probably be letting loose if we went by her? But that's what she wants. She's funded by George Soros. She, there is something that she calls herself a progressive, so we know she is far left. She believes in defunding the police. So that's the kind of mindset we're dealing with. And it is so funny. Ketanji Brown Jackson had problems with filing sexual charges. She had the same issue. It's so funny how these prosecutors seem to have such a hard problem with fully prosecuting to the fullest extent of the law these people who are involved in essay crimes. I don't know. It's something really weird with it. But if you read material from the people that they like and love, the little Marxist, communist philosophers, they don't believe that children should be innocent. They want them to be part of the revolution too. They want to drain out any semblance of the image of God in all people. They want to rip your identity from you. These people are wicked. Those are my thoughts. Let me know what you think about what I think in the comment section below. I will see you next time. Thank you for watching. Bye-bye. Don't forget to share this video. Please share this video so other people can know what is going on, and subscribe.